Almost all Americans are familiar with the famous phrase, "All men are created equal." But that phrase doesn't come from the United States Constitution. It comes from the Declaration of Independence. And as eloquent as the Declaration of Independence is, it's just a statement of principles. It carries absolutely no legal weight in the United States. Written in 1787, the U.S. Constitution is the document that serves as the legal foundation for American government, and the original Constitution was simply not concerned with the issue of equality. In fact, in order to secure an agreement at the Constitutional Convention, the founders from the North agreed to permit slavery to continue. It's written right into the Constitution. The original Constitution had 3 provisions dealing directly with the issue of slavery: the 3/5 Compromise, the 1808 provision, and the Fugitive Slave Clause. The 3/5 Compromise is the most well-known constitutional provision dealing with slavery. All delegates to the Constitutional Convention agreed that America should conduct a census every 10 years to count its population. Knowing the nation's population was important, because it determined the size of each state's membership in the House of Representatives. The problem was that the North and the South disagreed on how and whether to count slaves. The South wanted slaves to be counted and included in the census figures, because it would increase their power in the House. The North disagreed, saying that the South considered slaves to be property rather than citizens. The result was the 3/5 Compromise. 5 slaves would count as the equivalent of 3 white people. Inequality was quantified and baked right into the Constitution. The second constitutional provision dealing with slavery is the 1808 provision. Delegates from the North wanted to ban the importation of slaves from abroad, while the South wanted it to continue. They agreed upon a provision that permitted the importation of slaves to continue until at least 1808. In 1808, Congress would have the power to ban the importation of slaves if it wished to do so. Congress did in fact ban the foreign slave trade in 1808, but the South only agreed to this provision because the slave trade was expensive, nasty business. And it knew that there would be enough slaves in America by 1808 that it wouldn't matter. Finally, the Fugitive Slave Clause required that any slave who happened to escape to a free state must be returned to their owner if apprehended. And, needless to say, the Constitution was completely silent on the issue of gender equality, much less any other kind of equality. As a result, America was divided into the slaveholding South and the slave-free North. But there was always an uneasy tension between them, which led to the Missouri Compromise of 1820. This law prohibited slavery above a certain latitudinal line on the map, running through the middle of the country. But this compromise was undone by the United States Supreme Court in the infamous case of Dred Scott v. Sandford. Dred Scott was a slave who was originally purchased in the slave state of Missouri. But for several years, his owner took him to Illinois and to the Wisconsin Territory, both of which prohibited slavery. He was later brought back to Missouri. He tried to purchase his freedom in 1846, but his owner refused. And so he filed a lawsuit that argued he was a free man due to his time in Illinois and Wisconsin. The Supreme Court rejected his argument in a 7-2 decision. In doing so, it issued an opinion that has become notorious for its blatant and casual racism. It said that Scott didn't even have the right to bring it because he was not a citizen in the meaning of the Constitution. According to the court, "We think black people are not included, and were not intended to be included, under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States." On the contrary, they were at that time considered as a subordinate and inferior class of beings who had been subjugated by the dominant race, and, whether emancipated or not, yet remained subject to their authority, and had no rights or privileges but such as those who held the power and the government might choose to grant them. The court also said, they had for more than a century before been regarded as beings of an inferior order, and altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit. He was bought and sold, and treated as an ordinary article of merchandise and traffic whenever a profit could be made by it. This opinion was at that time fixed and universal in the civilized portion of the white race. At the core of the court's legal argument was a distinction between state citizenship and federal citizenship. The United States is a federal system. The federal government has a constitution that gives people certain rights. States also have constitutions that give people certain rights. The federal government can't give people rights that they don't have under the federal constitution, and since Dred Scott was not a citizen, but merely property, under the federal constitution, he had no right to sue in federal court. Still considered one of the Supreme Court's very worst decisions, Dred Scott was decided in 1856. It would take a civil war and 3 constitutional amendments to undo the damage.